SJC-11388, Commonwealth v. Seth Andrade.
Yes, ma'am. Good morning.
Good morning, Your Honors. Catherine Neves. I'm here this morning on behalf of the defendant appellant, Seth Andrade. I'd like to start with the first issue in my brief, which concerns the question on voir dire requested by the Commonwealth concerning the juror's ability to convict based on the nature of the Commonwealth's circumstantial case. There's no question that that question, as implemented, removed certain jurors who could have been impartial because they were not questioned further concerning their answers. But the question should not have been asked at all.
There was no objection to the question.
That is correct, Your Honor. There was no objection. So the court's review here is whether there was an error and whether there is a substantial likelihood of a miscarriage of justice. But the question should not have been asked as it did not pertain to potential extraneous influences on the venire. Instead, the issue of the circumstantial nature of the Commonwealth's evidence is the subject of instruction at the end of the case, at which the seated jury is presumed to follow instruction. The problem with this question, I think, was demonstrated with one of the jurors who ultimately was removed for cause, but I thought that his explanation was quite cogent about the problem with asking jurors not about something extraneous to the evidence they're going to hear, like questions about racial bias, perhaps, or domestic violence, perhaps, but purely about legal principles such as circumstantial evidence, and that circumstantial evidence alone is sufficient to convict. And what this juror said was, it's too hypothetical. I can't answer that question for you, black or white, without hearing how the case comes in. I can't answer it. And the judge dismissed him for cause. He is one of 9 who were dismissed for cause after having given ambiguous, at best, answers. A number of them said probably. A couple said, I think I'd want an eyewitness. Those are not people who were biased. These are people who were suitably skeptical about the notion that you could convict somebody based on circumstantial evidence alone. There are a lot of lay people who are skeptical about the notion of joint venture, that a fellow who's driving the car and the fellow in the back seat has a gun and they only mean to take $20 from the 7-Eleven and the clerk gets shot, that the driver is going to spend his life in prison as well as a joint venturer. But what we expect with the law is that when we bring people from the community, some who are more skeptical and have a point of view that how can that be, and others who say, sure, absolutely, get these people off the street, when you put them all together and you present the evidence to them and you instruct them on the law and you tell them, you must accept my instructions on the law, and they go into the room and they deliberate, that's a fair and impartial jury. And how that all shakes out, we don't know, because we don't impinge on the jury's function. And that's the problem with a question like this. It does not go to an extraneous matter. It goes to exactly what the Commonwealth was going to present here. And as implemented, it removed 9 people who expressed skepticism about the nature of the evidence they were going to hear.
Have we approved such questions as being within the judge's discretion in other cases?
I looked at as many cases as I could find. The case I found that really went to, the only 2 cases that I found that went to notions of sort of legal issues, pure legal issues, not something extraneous, other than, sure, domestic violence, but that related to perhaps something extraneous with a juror's experience. The case Morales, which is cited in my brief, 440 Mass 536, that was where the defendant requested in questioning about self-defense and the issue of self-defense. The trial judge declined to do it, and this court said that was not an abuse of discretion because there was no evidence that there were problems with jurors with the, having problems with the notion of self-defense. This court, pursuant to its superintendent's authority, has expanded the list of questions that must be asked if a defendant requests, but they, again, go to extraneous issues, extraneous considerations that a juror may bring from his or her experience into the courtroom.
But what about the cases really concerning whether a juror could convict in the absence of scientific evidence, for example?
Well, I think that's I think that this court has expressed skepticism but has upheld it. But again, that is an extraneous influence. It's supposedly the effect of watching all of these CSI and Law and Order shows, which are on every channel and every hour of the day, and people watch them, and that they have affected perhaps the jury pool as a whole to think that you can't convict without scientific evidence.
Or that scientific evidence is easily obtainable in every case.
Correct. And so this court has said, that's okay. We're not finding that the question, although the court said in gray, the question asked there came a little closer to a problem with Bowdoin. I think that's still an extraneous influence situation.
Well,
this is not an extraneous influence situation.
Well, then, I think if I follow you, you would say that in a case where a judge inquired of jurors if they could believe a person of color who testified, and they said, no, I can't, that the judge should sit that person because the judge will give them instructions which we assume they will follow.
No.
What's the difference?
Oh, absolutely there's a difference because, that's covered in the statute, 234, Section 28, and that is a pervasive bias belief system that's inappropriate, and this court and every court has said that's inappropriate. That is very different, a personal point of view about the nature of a particular person testifying. So again, the notion of, that certain classes of people and certain classes of defendants or victims, that is not appropriate because that is an extraneous influence. It's something the juror brings into the courtroom that demonstrates that that person, if they answer in that way, cannot be impartial. You're going to hear no eyewitness testimony. The Commonwealth's not going to give you eyewitness testimony. And would you be prevented from convicting?
Well, there was more than that. The judge read, the Commonwealth's case will be based largely on testimony and forensic evidence that's often referred to as circumstantial evidence. Circumstantial evidence is proof of a chain of circumstances from which you can infer that a fact exists. With the fact that you would not hear eyewitness testimony, the actual shooting in and of itself prevent you from finding the defendant guilty if the Commonwealth, through circumstantial evidence, is able to convince you beyond a reasonable doubt of the defendant's guilt.
Yes, that's correct.
Right.
I was just sort of summarizing that
I
last
don't think that's an
question.
accurate summary, what you were just giving.
Oh, I apologize, Your Honor. I didn't mean to mischaracterize
I mean, because
that.
they're just saying, even in and of itself, if the fact that you don't hear
Right.
somebody say, I saw it happen,
Right.
even though there is, through circumstantial evidence, the Commonwealth is able to convince you beyond a reasonable doubt of the defendant's guilt.
Right. And I think that there are a couple of issues with that. Number one, I still have the problem with the whole notion that it's not extraneous. It really is sort of.
Well, it's jurors bringing to bear a notion that unless somebody has seen it with their own eyes, it's not proven.
Right. And so there were 4 people who unequivocally said yes, they were gone. So if this court does not, sort of go along with my idea that things that are really outside, as opposed to legal principles that lay people are instructed about at the end, those 4 were gone, but there were 9 who said, probably, I don't know, I think I would want an eyewitness, and they were all excused.
That's sort of the height of a judge's discretion in eyeballing the witnesses, the potential jurors, and saying that, I think that this is a suitable juror, not a suitable. When have we tipped a judge for exercising that kind of discretion as to whether or not somebody would make a suitable juror?
I think in this case, you have an abusive discretion when you remove jurors who are not shown to be partial, and based on the ambiguous answers, would actually be perhaps appropriately skeptical about the Commonwealth's evidence, because at that point, the discretion has been exercised to deprive the defendant of a fair and impartial jury. I think in that that is the circumstance here, that these people were removed. And I would direct the court to the evidence in this case. No eyewitnesses. The only forensic evidence is a minute amount of gunshot residue on the cuff and one pocket. No confession, except for what Mr. Andrade allegedly said to Edwin Jorge. And on this Thin case, which the judge herself noted, this is not an overwhelming case in discussing another issue.
But you did have eyewitnesses who placed the men who were seen leaving, one of them wearing the same color jacket.
Absolutely. I would not disagree with the idea that the Commonwealth's evidence was overwhelming, that Mr. Andrade was in the yard that night at some point. He himself said that in his interview.
Well, he also said that he had been, that his explanation for the gunshot residue was that he had been shooting his gun at his aunt's home in Dartmouth, I think.
That's right.
And she said he had never been there, never shot a gun. So that explanation didn't hold water. And so it seems to me that there was more than enough there.
Oh, I'm not questioning the sufficiency. I'm just saying that by no means was this an overwhelming open and closed case. This wasn't a situation where, there were 3 or 4 people who said, that's the guy right there, he shot him, he had the gun, there's a gun, it's got his fingerprint. I mean, there was nothing like that. And in a case like that, I would ask the court to look at how long the jury deliberated. It's a first-degree murder case. They went out at 10:41 in the morning, and they were back at 3:09 on a thin case. So
How can you say, I guess thin is an interesting way to characterize it. The defendant says, I was there.
correct.
The other guy shot him, right?
Or this fourth guy shot him?
The
Fourth guy.
Fourth guy shot him.
Right.
Okay.
Right. Well, and the third guy, Tyrone Solano, invoked his Fifth Amendment right to not incriminate himself, did not testify. He was charged after his appearance at the grand jury with accessory after the fact and intimidation of a witness. His house was the house where the tan Carhartt jacket was found. His blue vest was never found. And Tyrone Solano, when you look at the evidence, Tyrone Solano, Jordan Jorge, Edwin Jorge, and the victim, all really good buddies. Mr. Andrade's the outlier. So, there was another person in that backyard, and Mr. Andrade doesn't say he wasn't in the backyard. He was in the backyard. And I just...
Well, actually, he told several stories. Eventually, he admitted to being in the back.
Correct. Certainly didn't want to be involved. There's no question about that. But I bring that up only to point out that for whatever it's worth, it was a very brief deliberation considering the charges and what was at stake and the nature of the evidence. As to the prosecutor's closing, it was not, as the prosecutor said. Anyone who listened to the medical examiner's testimony could tell which was the finishing shot. What it actually was anyone who watched Edwin Jorge's demonstration of what Mr. Andrade allegedly showed him about how the victim was shot could tell which was the finishing shot. And that's the problem with the mischaracterization. The medical examiner said quite clearly, and despite repeated questions by the prosecutor, he couldn't tell which shot came first. He couldn't tell...
Based on the medical, on what he had before him, right?
Correct. He could not, he would not...
Any extraneous evidence regarding...
Right. He could not
Right.
do a hypothesis about that. He could not say what the positions were of the people who, the shooter and the victim, when the shots were fired. He said he could say that one, assuming that the victim was in the standard anatomical position, was upwards and one was downwards, but he emphasized he had no idea what they were. So,
But the prosecutor never said that the medical examiner knew the order in which the wounds were received.
no, he said that anyone who listened to the medical examiner's testimony would know which order they were received, and that's not the case. You could not tell from that. What you could tell from was from Edwin Jorge's demonstration, and that's when the prosecutor goes on to say that.
Couldn't you also say that from the medical examiner you knew what position the body was found in? And the body was lying on its back, and that from that you could deduce or infer which shot came. And not saying that the medical examiner did that, but that the jury could infer it.
I don't think you could from what the medical examiner said. I think the prosecutor could make that argument based on what the medical examiner testified and based on what Edwin Jorge testified to together. But you could not get it from what the medical examiner testified to. He was quite adamant that he had no way of knowing what position people were in.
But the medical examiner offered information about the angle of the shots, the stippling effects.
He only about the angle of the shots.
Heard. So there was stuff that the medical examiner testified to that could lead somebody to make inferences about how this had occurred, even if the medical examiner himself or herself was not able to form an opinion.
Perhaps I could not, I don't think I could draw the inference from my reading of what the medical examiner testified to, but I could from reading his testimony and then reading Edwin Jorge's. I don't think it was possible.
And the
I
finishing
didn't-
shot notion came from the defendant himself.
Oh, sure. The finishing shot notion is not what's at issue here. I mean, I suppose anybody knows if there's two shots, the second one is the finishing shot. I mean, that's not really the point here. The point is...
Maybe not.
Oh, maybe not. But I think that, the colloquial notion of that is that that's the finishing shot. If you didn't see it, if you only heard it, if you hear a second shot, you're thinking it takes the second shot. I don't quarrel with that per se. My quarrel is with using the medical examiner's testimony, and who was a very credible witness and who declined repeatedly to give more than he felt he could give based on what was presented to him, and really using it to bolster Edwin Jorge, who was an extremely credibility-challenged witness. He had...
The jury would have understood through the cross-examination of Mr. Jorge, right?
Oh, certainly, certainly. But I think the problem is that, as the judge herself said, I don't remember, she herself didn't remember. I can't make much of this. I don't remember what the medical examiner said. And so the notion of who said what, I mean, the jury might not remember that either. To say, geez, it was Edwin Jorge, that guy who, he's got the deal and he's immune from prosecution and on and on. I mean, it was the subject of objection. The defense counsel found it objectionable. So that is some indication to the court that this was a problem. And he argued at quite a long time about it. And finally, just as to the final issue, the vouching essentially for Edwin Jorge, I think it's two principles. It's an old principle that it's fundamental that you can't ask a witness on the stand if he's telling the truth. That's exactly what the prosecutor did here.
But you can't, so the witness has been impeached. You've lied here, you've lied there, you lied this time, you lied that time. Prosecutor gets
Sure.
up and says, are you telling the truth today? Can't do it. You
No.
admit you lied all those time. Are you telling us the truth now?
No,
Can't do that.
the case law says no. You can't do that. You can do it a lot of different ways, but you can't ask the witness himself, "Are you telling us the truth today?" You can do what he did. He did a lot of, explain why he lied to the police at first, why he lied to the grand jury, why he did certain things to rehabilitate him. He could have even gone through the immunity agreement saying that there's a requirement that, you give truthful testimony. That was appropriate on redirect. Not appropriate to ask him to comment on his own credibility on the
Now,
stand.
The judge gave a Champa instruction that was
Yes.
thorough and correct.
Yes, but I think a curative instruction was necessary. There was an objection.
Requested?
Yes, well, not one request, no, there was an objection and it was overruled. It was not requested. But as this court had said in Rosario, in a case where there was an objectionable, that curative instruction went a long way to solve the problem.
Thank you, counsel.
Thank you.
May it please the court, Tara Blackman for the Commonwealth. The first issue I'm going to address is the judge's question to the jury veneer about eyewitness testimony and whether they would be able to decide the case and convict the defendant without eyewitness testimony if and only if the Commonwealth proved its case beyond a reasonable doubt with circumstantial evidence.
How often is such a question used?
I don't know precisely how often such a question is used, Your Honor. I couldn't find any cases where this specific type of question was used, but I would say that there's no real distinction between this type of question and the CSI type of question, which this court has repeatedly said in Commonwealth versus Perez, in Commonwealth versus Gray, is within the judge's discretion to ask the
But
jury
we say
veneer.
that you should use them with real caution.
Of course, Your Honor.
And so why would you go further than that here? I mean, because eyewitness testimony itself is somewhat subject to criticism or question, let's say.
Well, I don't think the question went further than those questions went in the type of way it was asked. As a matter of fact, I think it was very similar to the question that was asked in Commonwealth versus Gray. So I don't think the judge took a step further. I think the judge asked precisely the type of question that was asked in Commonwealth versus Gray, which this court said, yes, should be asked with caution, but is within the judge's discretion to ask.
Even assuming for the moment that that was okay, I'm not saying that it is or isn't, why is it okay on further questioning when someone says, I can't answer that in the hypothetical, it's really hard, I want to see what why would that be an appropriate dismissal for cause?
Well, I understand what you're saying, Your Honor, and I would say that if there's any suggestion that a juror is bringing bias, has a bias, say, toward they're looking for CSI-type evidence, they're looking for eyewitness testimony.
But in this particular juror's case, he wasn't saying, I'm just saying I can't answer in the hypothetical how I would respond to. Wouldn't it depend on weighing that kind of evidence?
Well, I think the judge in this case was being extra cautious. She was trying to see who was very clear that they would be able to decide the case without eyewitness testimony. And I think that the problem here, one of the main problems here, is we never have an objection from the defense counsel. We don't have an objection when the Commonwealth is asking that this question be asked. We don't have an objection when the judge says she's going to ask this question. And then we don't have an objection anytime this question is being asked or anytime the judge excuses one of these jurors for cause. Now, I think that if there had been an objection, the judge might have gone on to ask a second question or delve more into the issue. But the problem is we don't have an objection in this case. And yes, it comes to the standard of looking at a substantial likelihood of a miscarriage of justice, but it also comes to another issue of whether or not the judge didn't have the opportunity, because the judge did not know the defense counsel was having a problem with excusing these jurors for cause. The defense in this case never filed a motion for new trial claiming that somebody should not have been excused who was excused or was on the juror for who should not have been on the jury. So this is more of an evidentiary issue. There was never a motion for new trial to determine whether or not the judge abused her discretion, because defense counsel never objected, never filed a motion for new trial. So under the judge's...
Motion for new trial on this issue. You can't gather together those jurors again.
Well, no, but if there was a specific claim, that's the problem with the fact that the defense didn't object at the time of trial. That's really what it comes down to. Defense counsel...
It would be an ineffective assistance of counsel claim, in other words. That they should have been objected to.
Well, the thing is the Commonwealth's position is, first of all, when it comes to a defective assistance of counsel claim, the defendant certainly wasn't deprived of anything, a substantial ground of defense in this case. And the Commonwealth's position is this was a discretionary matter, and there's really no distinction between this and CSI type evidence or any type of bias that a juror might have that they come to the table with.
Was the defendant satisfied with the jury?
Yes.
Did he exhaust his challenges?
I don't recall whether or not defense counsel exhausted the challenges, but I do know that they both expressed satisfaction with the jury pool at the end. So I do know that. And I think that this was certainly, I think that my sister is trying to make a distinction between the question that was asked in this case and other types of questions, and she refers to as extraneous influence. The question really is about the same thing, whether or not any jurors are coming with a bias. And
Bias, or is it just sort of preconceptions?
or preconception, but I think that's same with respect to CSI type evidence. If there's a preconception, if there's something that a juror is looking for in the evidence that might not come out, this is a cautionary instruction just to make sure the jury can put aside any biases or any preconceived notions they have about what they're expecting to come out in any case, and look away from that and say, look, I can decide this case based on circumstantial evidence without any eyewitness testimony. And this is the exact type of instruction that's given in the cases at the end, that's approved of, that the judge gives at the end. The case, you look at all of the evidence, there's direct evidence, there's circumstantial evidence, there need not be direct evidence as long as the Commonwealth has proved this case beyond a reasonable doubt.
Same kind of issues as the scientific evidence does, by way of sort of, coming pretty close to a Bowden problem?
I think it's a similar issue, but I think that I don't think
Have a Bowden problem with eyewitnesses?
No, we don't have the Bowden problem. No, but I think that the concerns are the same. The concerns are certainly the same. That and why this court has said that it has to be exercised with caution, because we don't want any suggestion in this court has said in Gray, this court has said in Perez, that we don't want any suggestion to the jury that the Commonwealth, that lessens the Commonwealth's burden, or that suggests to the jury that it's not something that they can take into consideration. The absence of such evidence isn't something that the jury can take into consideration. But I don't think the judge's question even came close to suggesting that. I think that the judge's question to the veneer was very clear as to what the judge was trying to make sure of. And I think that there's no real distinction between this and the type of question that was asked and that has been approved of in Perez and in Gray.
Apart from the fact that I think, as I remember it, there's the statutory question about giving greater weight to the testimony of a police officer. Statutory question. Mm-hmm. What's the difference between that and this question? Is it a question of bias, or is it a question of preconceived notion? And what's the difference between them?
Well, I would say that it's a question of, I would suppose that it would be a question of preconceived notion in this case, that you should have a certain type of evidence.
But what about the police officer question? Is that a question of bias or preconceived notion?
Preconceived notion.
Not bias.
I would say it's hard. It's very hard to distinguish. I would say it's preconceived notion that an officer is more credible than an ordinary witness. So, but I don't see how this really is different from. I don't see how this is really different from, as I said, the type of other types of questions that are proved in this court. I don't think that this court has ever said that this type of question isn't within a judge's discretion, or as this court has already pointed out, I can't find a case where this court has ever said it's abuse of discretion to ask. Again, there are no cases that say the question about eyewitness testimony, this is okay. Because I couldn't find a case where this has specifically been looked at, this exact precise type of question. But it is, I don't see the distinction between this and, say, CSI type of evidence. That's also a preconceived notion.
But you'd agree, wouldn't you, that if the jurors could reasonably understand that they were being told you can't, you must ignore the absence of eyewitness?
And that would be a problem, Your Honor, but they were not asked, they were not told that you must ignore the absence of that evidence. And I think that's the concern that this court looked at in Gray. Is that what was being asked? Was the jury being asked or told, or was it a suggestion, you have to ignore the absence of such evidence? And this court found that the question that was asked, which is exactly the same, except to present eyewitness testimony in this case.
Counsel, you keep mentioning Gray.
Yes,
Am I mishearing you? I don't see a Gray case cited in your brief. I see Grant.
it's Gray. I apologize for the error, but
Grant?
it is Gray. It is Gray. Yes,
Okay.
the site's correct. Yes, I apologize for
Grant
that.
is
I noticed
Gray.
that this
Okay.
morning. Yes, 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 it is Gray. And this is precisely the same question that was asked. I would say that if there was see, the problem we have here is that, and I think, is that there was, when one of the jurors expressed ambiguity about their ability to put aside any view they had about eyewitness testimony, the judge did excuse that juror, and immediately, and she didn't go into further questioning. So there was never any suggestion, there was never any follow-up question to these jurors that would have suggested to them that that there may be something that they should look for. The absence of this evidence would in any way, they should not be, they shouldn't be able to take into consideration the absence of this evidence. Defense counsel never objected and said, this witness is just expressing ambiguity. Can we delve further? So the judge never had that opportunity to ask any further questions. But there's no suggestion on the part of the question, on the questions, based on the questions that were asked, that any juror who had any view that the absence of such evidence couldn't be considered was sat on the jury. There was no suggestion of
But, you know,
that.
you're putting your finger on I think where the concern is you could look at what some of the jurors had to say when being questioned as maybe saying, but I don't know if I could ignore the absence of, you could understand some of those comments that way, I think.
Right, they're saying they don't understand, they don't know, they don't understand, and if the defense counsel had objected, then the judge would have had the opportunity to ask a follow-up question. The judge here did not know defense counsel had a problem with it, but the question comes down to, was this an unbiased jury? And there's no suggestion that this wasn't an unbiased jury. There's no suggestion that the defendant in this case did not have a fair jury pool, a fair jury veneer. There certainly may have been other jurors who could have feasibly been sat if defense counsel had objected when one of these jurors, one of the 9 of the 13 jurors expressed ambiguity and said, look, judge, I want a follow-up question. Maybe this juror can be sat. The defense counsel never did that, but I don't think that this certainly doesn't rise to ineffective assistance of counsel. There's no suggestion that defendant was deprived of substantial grounds of defense in this case. And again, defense counsel didn't object. This was a matter of discretion. The judge took extra precautions, and I don't think that this type of question is any real different, there's any real difference, any substantive difference between this and the question about substantively about CSI type evidence.
What advantage would it have been to a defense lawyer to have requested this question himself or herself? The question about circumstantial evidence.
I don't know if the defendant would have specifically, there was any real benefit, but I don't see how that's any different from the CSI type evidence and asking, can you put aside any preconceived notion, biases, or anything you're looking for about CSI type evidence? Would the absence of that prevent you? So I don't think that there's any real difference with respect to that. I mean, the Commonwealth, just like the defendant, is entitled to a jury pool, a jury veneer with and jurors who don't have any biases about anything regarding the defendant's, say, gang affiliation, or defendants color, or any other issue. The Commonwealth is similarly entitled to a jury pool who is able to decide the case without those preconceived notions of the specific type of evidence that they're looking for. Where the Commonwealth's burden of proof is very clear. They need to prove the case beyond a reasonable doubt, but they could do so beyond circumstantial evidence. So I don't think that there's any clear benefit to the defendant in this type of case, in this case specifically, from the question that was asked, the absence of eyewitness testimony. But again, I don't see how it's any different from the CSI type of evidence. And I know my sister says, look, it's about extraneous influence. But I don't think that, I think it's similarly, there's also extraneous influences where you see TV shows and you want an eyewitness who comes up, or movies where you see an eyewitness who at the end comes up and says, look, I saw the defendant shoot the victim. Sure, that's it's a preconceived notion about what jurors are looking for. And just as the defendant is entitled to a jury without certain biases, so be it is the Commonwealth.
I'd like to direct your attention to the vouching issue.
Yes, Your Honor.
Could a lawyer ask a witness that the lawyer called, are you telling, any witness, in fact, preferably a non-Champa type witness, any witness, are you telling us the truth today? Is that an appropriate question?
Certainly that would have been completely inappropriate on direct examination. Completely inappropriate. But that's not what happened. What happened, the prosecutor did not ask any questions about the truthfulness of the witness of Edwin Jorge's Edwin Jorge's credibility on direct examination. What happened was there's direct examination. During cross-examination, defense counsel spent the crux of his cross-examination trying to impeach Edwin Jorge, bringing up prior inconsistent statements, bringing up prior inconsistent statements to the police during the police interviews, prior inconsistent statements to the grand jury, and also Edwin Jorge's plea deal, and focusing on Edwin Jorge's plea deal with the Commonwealth and how it put into question his credibility. And it's very well established law that the Commonwealth is entitled on redirect examination to rehabilitate its own witness. And what this really came down to was the prosecutor asking Edwin Jorge, which version, what it really comes down to substantially is which version is the truth that you told. The prior inconsistent statements, which defense counsel just tried to show, in which you said that you didn't even know the defendant before this night, the defendant made other statements about someone else shooting the victim, or the statement that you gave today on direct examination. I think this is just a very clear example of the prosecutor rehabilitating his own witness. Also, I want to point out that it was very clear from the prosecutor's closing argument, he was not vouching for Edwin Jorge, because the prosecutor himself brought out the fact, look, Commonwealth admits there was a problem with Edwin Jorge's testimony. He had a plea deal with the Commonwealth. I ask you to use your common sense in looking at this witness. So it was very clear to the jury that the prosecutor was not vouching from this witness, not only from his direct and from his redirect, but from his closing argument, in which he made very clear that there were problems with this witness. Look at it all, look at the facts, look at what he told you today, and use your common sense. And he specifically said, use your common sense in looking at the credibility of this witness. And then, of course, we also have the judge's instruction to the jury. First of all, as this court has already pointed out, the judge gave the Champa instruction, making very clear that the jury should look at these any witnesses who were involved in plea deals with caution, specifically naming Edwin Jorge as one of those witnesses. Also, the judge gave a very clear instruction that closing arguments are not evidence and that questions to the witnesses are not evidence. So I think that as a whole, it would be very, very clear to the jury that nobody was vouching for this witness, and that any questions about assessing the credibility, I certainly don't think in this case would have risen to prejudicial error, even if this court was to find that last question about whether or not your direct examination about what the defendant told you was truthful. So even if this court found that maybe that question should not have been asked, that final question, it certainly did not rise to the level of prejudicial error, and especially considering the overwhelming evidence in this case. And the Commonwealth would disagree with my sister that although there was no eyewitness testimony, the circumstantial evidence certainly was overwhelming, even though there was limited forensic evidence. The limited forensic evidence was certainly very inculpatory. Gunshot residue on the jacket, which the defendant admitted it was his, and no evidence of anybody else in that backyard except him and Tyrod Solano. The defendant's own statements to the police, and then the testimony of Edwin Jorge, which, of course, the jury were entitled to look upon with skepticism and to assess the credibility, and they were informed of that, but an admission on the part of the defendant, no
Can I
less.
ask you one question? There was a videotape of the area where the shooting took place.
Correct, there were surveillance.
And we saw the 3 men coming and going, but we never
Exactly.
saw a 4th man coming and going.
Exactly. Well, in the beginning, their surveillance tapes, right? I think that Jordan George was with them, yes, but there's no evidence of any other additional man who the defendant says was there. There's no evidence of that. Nobody even sees they see 2 people. There are witnesses who see 2 men running out of that complex. One of them wearing the type of jacket that the defendant admits was his, and he was wearing that night. Then another man wearing a dark sweatshirt, which Tyrone Solano was wearing. There's no other evidence of any other person being in that backyard, coming out of that backyard, nobody seeing them. And then, of course, we have the defendant's own contradictory statements to the police throughout the police interview. So I'd say in light of all of that, there was overwhelming evidence, of circumstantial evidence of the defendant's guilt.
Thank you, counsel.
Thank you, Your Honor. Thanks.